Important maritime law acts in Texas. Maritime injury cases and property damage cases are dealt with using a series of acts and general maritime law principles that have been built up over many years. Legal principles governing the right to compensation and medical expenses for an offshore injury, and jurisdiction for claims are set out in these acts. Longshore and Harbor Workers' Compensation Act. The Longshore and Harbor Workers' Compensation Act, LCA, serves to compensate many different types of maritime employees. Some examples of workers that can claim under this act include harbor construction workers, longshore workers, dock workers, cargo workers, ship repairers, shipbuilders. In order to make a compensation claim under this act for a maritime injury, the worker must demonstrate that they are a maritime worker and that their injury occurred on navigable waters or adjacent to such waters, including docks, piers, etc. Outer Continental Shelf Lands Act. The Outer Continental Shelf Lands Act is an extension of the LCA. Workers who are injured on the outer continental shelf of the United States are entitled to make an injury claim under this act. They must show that their work was in relation to exploring and producing natural resources. If you work on an outer continental shelf oil rig, you may be entitled to file a maritime injury claim under this act. However, if you are employed by the U.S. government, a foreign government, or a state government, you will be exempt from filing a personal injury claim under the Outer Continental Shelf Lands Act. Death on the High Seas Act. All deaths that occur on the high seas, outside of a state's territorial waters, are covered under the Death on the High Seas Act. This act provides that family members of workers and passengers who die due to an accident at shore caused by wrongful act, neglect, or default occurring on the high seas can bring a lawsuit. Family members can only recover compensation for pecuniary losses, like financial support, and will be unable to recover medical expenses and funeral costs. The statute of limitations for bringing claims under this act is 3 years. Common maritime injury cases in Houston, Texas. Many offshore workers risk their lives going to work every day. Due to the nature of many maritime jobs, workers are at risk of being seriously harmed due to work hazard environments, such as even falling objects, gas explosions and fires, faulty machinery, and much more. Maritime law and admiralty law have provisions for workers to get compensation for their injuries and to ensure that their medical expenses are covered. Common injuries sustained by maritime workers in Houston, Texas. Depending on the type of offshore accident, a maritime worker may sustain serious or even fatal injuries. Maritime law ensures that workers are entitled to receive compensation for these injuries. However, in many cases, vessel owners and employers are reluctant to pay out high amounts of compensation. By filing a lawsuit or getting help from a Houston offshore accident lawyer, you can substantially increase your chances of getting fairly compensated. What rights do injured maritime workers have in Houston, Texas? It is important to be aware of your legal rights as a maritime worker at all times. If you get into an offshore accident and suffer injuries as a result, you should ensure that you have access to medical treatment, that your legal rights are protected, and that you are financially supported. All injured maritime workers are entitled to the following: medical treatment. Under the Jones Act, All injured maritime workers are entitled to receive medical treatment that is covered financially. Injured workers do not have to worry about having insurance or paying for medical expenses, as they are entitled to receive financial maintenance payments and all medical benefits. If you had a pre-existing injury made worse due to the maritime accident, your employer must provide sufficient coverage for your medical treatment. In the event that one doctor says you need medical treatment and another doctor says it is not necessary, the Jones Act adds in favor of you receiving treatment. Choice of doctor. All injured offshore workers have the right to choose the medical professional that treats their injuries. You may have to have your first evaluation with a doctor recommended by your insurance company or employer. However, who you decide to get treated by is at your discretion. Non-recorded accident statement. When you are first injured in a maritime accident, you must report the accident to your employer or the appropriate party at the site of the injury. However, you are not required to give a recorded statement of the accident. Often, shock and pain can cause people to mix up facts or get confused initially, which is why you should not record a statement that you may need to change at a later date.